They have smart water, so maybe that's what they have.
Hey, this is all I have in the market.
Fair.
It's 4 o'clock on
But it would
Saturday.
be funny if someone, because that's,
Guy, what's the baby name? Yeah. Yeah.
keep referring to the baby as an it. I don't know. Do they say the gender?
They don't. I just say JR.
I don't really, I just say like the child.
It could be Jane something. JR. First one? That's good. That's good. I need like COVID for that one. I don't know. It's called. Yeah, wait, so. I'll take two. Three. I'll give you three. Dad had a friend. Dad had a friend. He would just sit down for like 10 minutes before he was done. That allows your voice to get deeper.
I was coming to city and
Okay.
need to find out where I'm.
Well, we're gonna be on the opposite side now, so you can see us.
No,
Or what? No, we are some
We're
side.
same side.
I guess we get to see the breeze.
Oh, yeah.
We got time. We got time.
Yeah, I would go ahead.
Hey, all rise. 16th Court of Appeals is now in session.
Please be seated. We are here to hear the case of Reed versus Walker. Can I have announcements from the parties?
Your Honor, my name is Brooke Thorne, and alongside my co-counsel, Hussein Naderzada, we represent the petitioner, Reed. And may we please request 4 minutes for rebuttal?
Sure. Will you be speaking first?
Yes, Your Honor, I'll be speaking on the first issue, the equal protection issue.
I'll be speaking on the second issue, the parentage contract.
Thank you.
Your Honor, my name is Dan Pansmancy III, and I, along with my co-counsel, Mr. Taraba Boss here, represent the respondent, Caroline.
Thank you very much. Ms. Thorne, you may proceed.
Your Honors, Chief Justice, may it please the court. My name is Brooke Thorne, and alongside my co-counsel, Hussein Naderzada, I represent petitioner Wyatt Reed. This is a case about a father who has been arbitrarily denied parental rights over a child with whom he desires and deserves to have a relationship. I ask that the court please affirm the trial court on the issue of equal protection. The trial court held that the denial of parental rights to petitioner is a violation of his equal protection rights under the Texas Constitution. This court held that a three-step analysis is employed when determining whether there has been a constitutional violation under the Texas Constitution. The analysis set forth in Bell v. Low-Income Women first looks at whether equality under the law has been denied. If it has, then the court looks at whether that equality was denied because of the person's membership in a protected class. If so, then it can only be upheld if it is narrowly tailored to serve a compelling governmental interest. The first prong of our equal protection analysis, whether equality has been denied under the law, is easily met. Section 160.703 of the Texas Family Code states that a father-child relationship is established when a husband provides sperm for the assisted reproduction of his wife. However, it does not provide for the same establishment of a father-child relationship when the donor is not married. The second prong of our equal protection analysis is also met. The only trait stopping petitioner from having parental rights is his marital status. Because marital status is the only difference between petitioner and a donor who is afforded parental rights, it must be because of petitioner's marital status that his rights are being denied.
But counsel, what about in the instance of same-sex couples where there's a donor to the situation and the woman who is receiving the material is married, but to a woman?
Yes, Your Honor. That is a different situation than we have here. And I'm not saying that every donor should have parental rights. What I'm saying is that denying petitioner the opportunity to show that he deserves to have a relationship with his child and that he is capable of having a substantial, close, familiar relationship with his child is a denial of his equal protection rights.
But in what I'm getting at is in that situation, he would not have rights to a relationship with his child. Do you agree with that?
I agree with that, Your Honor. And in that situation, I'd also assume that the donor wasn't intending to have rights when he donated. I mean, maybe it was, I'm not sure what you meant exactly with your situation, but if it was through a sperm bank or something like that, then the donor would not have intended to have parental rights. In this case, both the petitioner and respondent agreed that petitioner would be the father of the child in question, and that is a very different situation than a donor donating to a same-sex couple.
So are you saying intent is at issue here?
Yes, Your Honor, and that is one of the things at issue here is the intent of specifically petitioner, but
Two people who happen to have sexual relationships, who do not intend to have a child at all, but do end up having a child. That man did not have an intent to have any sort of relationship, let alone be a parent. Are you saying then he could be deprived of his rights on that basis?
of course not, Your Honor. The situation I'm talking about here and where intent comes into play is when it's in the situation of assisted reproduction, which is different from two people having sex and resulting in an unwanted child. Accidental.
And you still feel like it's a violation of equal protection, given that there are potential other avenues that he could go about to establish his right to a potential a paternal relationship?
Your Honor, it is a violation of equal protection because he is being completely denied having access to his child and parental rights over his child when the only basis for that denial is the fact that he's not married to the respondent.
Is that the only basis for denial? Did he try his other avenues to establish parental rights?
Your Honor, I believe that the parenting agreement entered into between petitioner and respondent was intended to kind of be a statement of intent from the father that this would be his child. There are procedural requirements. However, petitioner here, when petitioner and respondent agreed, what they both had in mind was that petitioner would be the father of the child. Petitioner had no reason to think that he would have to use other avenues.
When I say other avenues, though, I mean legal avenues. He's being denied in this particular way, but he has other ways to attack the problem and achieve what he's looking for, which is a declaration of paternity. So my question is, you still feel like he's being denied his rights under the law if he's not using all of the alternatives available to him?
Your Honor, I still believe this is a violation of his equal protection rights, and not just because looking at this specific case, but because the way the statute treats unmarried and married men differently. And that distinction they make in the statute is not a narrowly tailored way to serve any compelling governmental interest. Petitioner concedes that the state has a compelling interest in promoting the best interest of the child. However, denying petitioner paternal rights solely because he is not married to respondent does not promote the best interest of the child. The fact that a man is married does not mean he will be a better father or even have a close relationship with the child. On the other hand, the fact that a man is unmarried does not mean that he won't have a close relationship with his child.
Can you explain the statute language specifically that you're saying that your client would?
Yes, Your Honor. I believe it is section 16703 of the Texas Family Code. And that states that a father-child relationship is established when a husband provides sperm for the assisted reproduction by his wife. And Your Honor, this distinction between married and unmarried men is both under and over-inclusive because it's over-inclusive because it includes people like petitioner who, although he did donate his sperm instead of doing it the traditional way, has shown a substantial interest in the life of his child and has shown that he wants to be an involved parent. It's under-inclusive because it includes and gives automatic parental rights to a married man who is a donor, while it may not be in the best interest of the child to permit him to have parental rights.
Where does the best interest of the child fall into this then, right? Because is this a presumption that's rebuttable by a best interest of the child analysis?
Your Honor, I am stating that the government's compelling interest is promoting the best interest of the child. And I'm stating that this distinction between unmarried and married donors does not serve that interest because it both includes people who should be able to establish paternal rights and it includes people who maybe shouldn't be able to have paternal rights, excludes people who should be able to establish that.
We have to presume that the legislature meant what they meant when they used the word husband in this statute. And therefore, I'm sure that that word is used in many other statutes throughout the government code. And so if we presume that the legislature didn't make a mistake here, or are you asking us to basically say that the legislature wrote the statute in a is the statute ambiguous on its face?
Your Honor, I'm arguing that the statute as applied to petitioner is unconstitutional because it denies him parental rights, and that denial, it does not promote the best interest of the child. And I'm arguing that the distinction the statute makes between married and unmarried donors is not narrowly tailored to serve a compelling
I'm
government.
confused on the point of, it seems that you're saying the best interest of the child is somehow coming into play with the constitutionality of the equal protection. Are those not two separate issues?
Your Honor, those are two separate issues, and in family law cases, we always talk about the best interest of the child. The way
That's a
it fits.
later analysis, is it not?
Sorry?
That's a later analysis, is it not? If we're talking about equal protection, where does best interest of the child come into play, whether or not it's equal protection granted to the man in this situation?
Your Honor, it comes into play with equal protection because it is the government's compelling interest to promote. I see I'm out of time. Could I?
Please finish the.
Okay, I will finish the question and briefly conclude if that's okay, Your Honor. I'm arguing that the government's compelling interest is promoting the best interest of the child, and that this distinction in the statute does not serve that interest. And because of that, we ask this court to please affirm the trial court on this issue. Thank you.
May it please the court. As my co-counsel has already stated, I'm Hussein Nadarzada. I'll be addressing the second issue on whether or not there was a parenting agreement. We're asking this court to overrule the trial court's decision that the co-parenting agreement was invalid. This is not a contract establishing parentage. This is a co-parenting agreement. Both Texas case law and the Texas Family Code distinguishes between the two. Parenthood is not simply defined by biology. It is shaped by intention, commitment, and the conscious decision to take on responsibility that come with raising a child. When Weed and Rocker entered into this parenting agreement, they crafted a collaborative plan, laying the foundation and the responsibilities that each would take on raising their child. Now, my first point, I want to say that the lower court failed to recognize that the respondent ratified the petitioner here as having a parent-child relationship. Now, in another analogous artificial insemination case, the Court of Appeals in San Antonio addressed the issues of ratification of a parent-child relationship. The case I'm talking about here specifically is KB versus NB. That case involved a married couple who conceived of a child through artificial insemination with the sperm donor. The husband did not provide written consent for that obligation. The issue in that case was whether the husband could still be considered a legal parent of the resulting child under Texas law. The court found that the husband ratified his parent-child relationship through his conduct, even though he had not initially consented to the artificial insemination. The court noted 3 factors in their reasoning.
What does that have to do with whether this is an enforceable contract? Connect the dots for me there.
Yes, Your Honor. I'm arguing today that by respondent's actions in this contract, that she ratified a parent-child relationship with the petitioner, having established those parental rights, and by crafting their co-parenting agreements, laying the foundation of the responsibilities in raising this child.
Okay, so you're saying that the parental rights they don't stem from the contract, that the contract is basically evidencing the fact that those parental rights had already been ratified?
Yes, Your Honor. I am arguing that the intent of the contract plus their co-parenting agreement in raising this child gives him parental rights to this child.
So you are saying that the contract gives some parental rights?
May you repeat that, Your Honor? I'm so sorry.
So the contract, what I'm confused about here is why the contract has to be related to the parental rights themselves. Can they not have the parenting plan, like you said, without conferring parental rights per se?
They can have the parental rights, but there is somewhere in the contract that says that they are going to confer parental status. What I'm arguing here today is
Why
that
not sever that to keep the rest of the contract enforceable?
that is exactly what I'm arguing, Your Honor. I'm arguing that this court remands it back to the lower courts and finding that. Here, Walker's actions demonstrate a clear ratification of Reed of having established that parent-child relationship by one, engaging in discussions of sharing financial responsibilities, by Reed accompanying Walker to her prenatal checkups, by three, agreeing to this contracts of shared financial responsibilities. My next point is that even if this court finds that Walker didn't ratify the contract, this contract is not contrary to public policy. The trial court improperly interpreted the terms of the contract as an attempt to establish parental rights. The contract here, as already stated, is a co-parenting agreement. And the Texas Family Code in Chapter 153 supports the ability to establish parenting agreements. If I may direct your attention to page 6 of the record, here the agreement states the term of who's going to care for the child, who will provide financial support, terms of assisting the respondent in caring for the child. Upholding this contract wouldn't conflict with public policy, but rather supports the child's best interest by providing an enforceable structure for financial and emotional support from both parties. There's nothing more here that supports the.
However, is this contract truly enforceable? What penalties are there against Reed for failing to meet the terms of the contract, which he apparently did according to the record?
Your Honor, if the respondent here has a claim that my client breached that contract, then I would suggest for them to take that claim. But in this case, they didn't sue for a breach of contract, and a court never ruled on whether or not we did breach a contract.
What is the standard typically applicable to just an agreed parenting plan?
The standard, it's set forth in Chapter 153. The chapter, it does state that an agreed parenting plan is not enforced as a contract. However, it is enforced as a judgment, let's say as a contempt. It still can be enforced.
And in what circumstances can a court override what the parents have agreed on in a parenting plan?
Let's say if it's not within the best interest of the child, then a court can override that, Your Honor. There's nothing more
So,
here.
I'm sorry, I don't know if I'm following here. Is it a parenting plan or is it a contract?
Today, Your Honor, we're here arguing that it is a parenting plan conferring parental rights and responsibilities to the petitioner.
Okay,
Without the parenting plan, would he not have rights and responsibilities?
Your Honor, there would be some ambiguity given the artificial insemination process as to whether or not he does have parental rights. But the fact that the two parties here mutually came together and had an attorney involved to establish their parental rights does show that they do have that the respondent here does want the respondent to have rights. There's nothing more here that supports the best interest of the child than ensuring that a child has an opportunity to have a meaningful relationship with his biological father. The petitioner here has taken every step to demonstrate that his commitment to this principle form, one, by providing financial support, accompanying Walker to prenatal checkups, purchasing baby clothing, and four, formalizing his intentions through this co-parenting agreement. There is nothing more here. That is the quintessential definition of the best interest of a child. And it is likely here that the respondent is going to argue that the petitioner here went on trips when his business was failing, but he did so, but he didn't do so to leave the child. He did so to make sure that he has enough financial support to get his business back on track in order to make sure that this kid has a meaningful life. Is that it, Your Honor? Do you have any more questions for the questions, Your Honor?
No, are you finished?
I am finished, Your Honor.
I have a question.
Yes, Your Honor.
So the parental contract, it looks like the lower court, they didn't void it because it wasn't in the best interest of the child. They voided it categorically as a matter of public policy, not this contract, all contracts like this. So why is it in the interest of public policy for a court to allow these types of contracts to persist if that would in effect being replace a best interest of the child analysis?
Your Honor, we're not arguing that a best interest of a child analysis should go away. We're here arguing today that these types of contracts, the trial court didn't properly interpret the terms of the contract. They just made a blanket statement saying that it was void. But when you do interpret the terms of the contract, it is a co-parenting agreement establishing parental rights. These types of contracts have always existed in the Texas family law and throughout Texas case law.
Well, let's break that up into two things, right? You have co-parenting agreements establishing financial responsibilities, visitation responsibilities, medical responsibilities, and it looks like what the lower court ruled here is you cannot have a contract basically that agrees to ownership of a child as if you were buying a car or selling a car or buying a house together.
Mhm.
And that's left to the other avenues to determine, like statute or best interest of the child analysis.
Is the parenting contract all that you are basing your rights to the child on?
Yes, Your Honor, we're basing our rights to the child based off of this co-parenting agreement. Is that it, Your Honor? Thank you so much. Thank you for your time.
Chief Justice, Your Honors, may it please the court. My name is Bien Panspansi III, and my co-counsel Taraba Boss, and I represent respondent Caroline Walker. I will go over why the trial court got this case right in dismissing the petitioner's case, and even if the petitioner has standing, he fails because he was not discriminated against under the Equal Protection Clause. My co-counsel will go over why the contract is invalid and unenforceable under public policy. The statutory framework validly distinguishes between donors and legal parents. The Texas Family Code creates this clear distinction between donors based on the nature of their conduct and not the gender. Section 160.1026 defines donor as someone who provides genetic material for assisted reproduction without intent to parent.
But he did intend to parent because there is a contract. Whether or not the contract was valid, how do you argue that he didn't have any intention to parent if he entered into a contract to parent?
Your Honor, there's multiple instances of this sort of lack of intent for him to truly want to parent. Throughout my argument, I will talk about it, but very briefly, I will just say that, yes, while he did intend to, initially, at least that's what it seemed like, he entered into the contract. There are instances of him being gone for a period of several months, as well as failing to make additional payments. And there was an instance where he very violently and recklessly in an intoxicated state
Tried to come in to see his child.
At what point do you measure the intent to parent? Is it before the insemination? Is it after the insemination, before the baby's born? When do you measure it?
Can it change? And if it can change, then is that a potential problem for every parenting analysis?
So it is our position that yes, it can change. We have conceded that, at least in the beginning, from intent, it's shown that he at least had some intent to parent. However, that changed with his actions by, again, violently breaking down the door, as well as not making any payments, as well as failing to really remain in contact with the mother for those several months that she was pregnant.
Does the record say anything about any criminal charges that were brought regarding the violently breaking down the door?
No, ma'am, there was no criminal charges for that.
Can you give us some examples of case law where the intent to parent changed over time?
Your Honor, in the case in Re T&T, they at least established that there is an ability for courts to go ahead and strip away parental access. And in that specific case, it was because the father had abandoned the child. So at least there is some case law to say that given actions and given this sort of intent, that there is this ability to strip access.
But I was not evaluating intent in the context of, is this person a donor or not? Is that correct? Is that correct?
Yes, ma'am.
And in that case, what was it the court used to establish abandonment?
It was that he had not seen his child for several years.
And in this case, you're saying Reed was gone for,
Several
I'm seeing
months.
the record, well, according to the record, it was 6 weeks before the child was born, or am I misreading the record?
I believe he was gone for several months just due to the international as well as domestic flights, and he even failed to see the child when the child was born. And it wasn't until roughly over a month after the child was born that he even asked to see the child. Okay. So petitioner Reed's conduct aligns with that of a donor. Genetic material was provided for assisted reproduction. The process was artificial and deliberate, not the product of a sexual relationship. Moreover, my client specifically stated that she did not want to have sexual relations with the petitioner. These distinctions reflect rational, biologically grounded classifications rather than impermissible discrimination.
But again, we have the same problem with just because someone is a donor,
Mhm.
if they, I mean, we're talking about intent, right? And so his intent was not merely to donate his sperm and then to, I mean, as it would be with a sperm bank, for instance. And to have no legal, financial, or, you know, emotional,
Correct.
physical relationship with that child. So how do you get around that idea of intent?
Correct, Your Honor. So petitioner would have you believe that because of the little intent that they've shown, that they should be able to therefore bypass these statutory requirements that have been held in Texas for years and years. Now, if the interest that they've had was truly there and he really did deeply desire to be a parent to this child, under section 160.102, he could, or sorry, 160.601, he could have filed for a parental adjudication, had gotten that parental status right then and there, and perhaps even avoided this costly litigation that we are here today.
Could he still do that?
Well, Your Honor, based on the facts of the record and given all that has happened here, it is our position that you affirm the trial court's decision and allow for us to strip the parental rights, just given the fact that it cannot be against public policy to strip the rights of someone who lacks clear intent for the child, and also has at least shown that when a disagreement comes and that he is enraged, that he is so willing to be violent and reckless and break down a door.
But again, there was no criminal charges filed. And isn't it in the best interest of a child to have two parents?
It is within the best interest of the child to have two parents. However, to have a child that so violently broke down a door, even though there was no criminal record, it is stated in the facts that he had to be removed from the premises.
The court has held that an incarcerated person who's been, and I don't know the specific facts of this case, but there are others, and I know we're restricted to these cases.
Mhm.
But the father who was incarcerated was not allowed to contract away his own rights because the court found that was against public policy. Read here, again, as the Chief Justice mentioned, no criminal charges were even brought. You claim that this was so violent, the police were called. They didn't find the need to arrest them or issue any citations or otherwise. What is it about his actions that rise to the, like you said earlier, abandonment required years of being away, or at least in that situation? I would like for you to explain what he's done that has risen to such a strict standard to where his parental rights should be taken away when the courts and everything in the record shows the public policy, and again, it's the Chief Justice mentioned, says that, and as you yourself admitted, that having two parents is in the best interest of the child.
Correct, Your Honor. So yes, having two parents is within the best interest of the child. But if the father is not able to show a real propensity that he's able to give the child a good future, it is against public policy. There are
Do you have
multiple.
case law to support that?
Yes, the Henry TNT case said that if that under abandonment, the child or the courts are able to strip away access. And moreover, seeing as how there is a multitude of circumstances, again, the being absent from the child, the lack of communication, as well as the violent propensity that he has. Moreover, while we are sympathetic to the financial situation of the petitioner, his financial aptitude is our position that it is at least in question. Now, so throughout the payments, he was able to make 5 payments, the last one being in March. It totaled less than $1,000.
If you strip his rights, she gets no payments.
Correct,
But
but
some payments better than no payments?
yes, Your Honor, but there's nothing in the record to point that if you were to keep his rights, that he would continue to make payments, because if
If he had rights, then the state would be able to force him to make payments, would they not?
they would be able to force, but the problem with that is even when his company was financially strong, he made 5 payments that totaled less than $1,000. There's nothing in the record to say that his finances have ever improved, that the Brood V disease has sort of lessened. There's
An
nothing to really
incarcerated
indicate.
man can make no payments,
Yes, sir.
yet the court found it was against public policy to take away his parental rights. I'm failing to see how this argument holds.
This argument holds because the totality of circumstances shows why it should be within public policy for a mother to strip away his rights. Again, while some payment is better than no payment, it's not clear that he will make any payment. And again, just based on the fact that the record's unclear whether or not the Brood V disease is still intact.
Second line of questioning then, you're saying that they're stripping away rights.
Mhm.
Does that imply that he has rights to begin with, or were rights never there inherently?
I apologize, Your Honor. So I did misspeak in that point. The rights were never there, but it's more so, I should say, access to the child that would be now stripped.
I want to ask a follow-up question to what my colleague asked earlier. So what would happen here if he left with an adjudication affirmed he has no parental rights?
Mhm.
Could he still go back and get an adjudication of parentage? Why was that never done in the first place?
Whether or not the parental adjudication, why it was not done is unclear per the record. I think maybe you would ask the petitioners that question, but it is our view that, again, because this has now risen to the level of the Court of Appeals, and again, given the finances of my client, she is a single mother who has already spent more than $30,000 caring for the child and assumed more money having to litigate this case. It is our position that you simply reverse to further avoid this costly litigation.
But you wouldn't be a single mother if you weren't trying to strip away the father's rights.
That is not totally correct, sir. It is per the record that their intentions were to never be together. It's not that they were to ever get married and then become a single family household.
So does this bring us back to the marriage issue?
So the marriage issue, while the petitioners try to create a distinction between unmarried as well as married people, the law is clear in that there is equal treatment of donors. The law applies equally to male and both female donors, treating both as non-parents until they fulfill that statutory requirement. In this situation, petitioner is held to not have parental status, but it would be the same if my client was the donor, creating this true fairness, and therefore it would not be an equal protection violation. Ultimately, again, while we are sympathetic to the situation of the petitioner, we never wish harm to go onto someone's business. Ultimately, he did not step up and my client did. I see that my time has stopped, Your Honors. Could I continue and briefly conclude? Okay. Ultimately, my client did. She has been there for her child from the very start and even on to now. It cannot be within public policy for a mother who has throughout the entire process shown that she has the best child's interests at heart to not be able to strip away access from a parent who has shown time and time again that he lacks this real interest. Now, again, Your Honor, for the sake of public policy litigation costs, the
That's
time.
good. Appreciate you.
Okay, thank you.
It wasn't, but you could have let it go.
May it please the court, Honorable Chief Justice and Honorable Justices, my name is Tarab Abbas, and I represent Ms. Caroline Walker, the respondent in this matter. And I will be arguing the second issue of the parental agreement at hand. The respondent respectfully asks the Honorable Court to affirm the lower court's ruling that the parenting contract between Ms. Walker and Mr. Reed is void as contrary to public policy. And our first line of argument is that Texas Family Code 153007 does not permit private parties to enter into a contract which is binding. The Texas Family Code 153007 allows for the parties to enter into a written agreed parenting plan containing provisions of conservatorship, possession, and interest of the child for the interest of the child and for modification of the parenting plan only after it has gone through judicial review. And only after a court finds that the agreed parenting plan is in the best interest of the child. Only and only
Are
then.
you saying that two parents who have not gone through any sort of judicial process, they're not allowed to come up with their own parenting plan? Or is it just that that would be unenforceable under the law?
Your Honor, both of those assertions are correct according to the respondent's view. Because Texas Family Code is unequivocally clear that a judicial review is required, especially when contracts or private party contracts are concerning child's best interest, and especially when the child is a minor.
But I have to disagree with you there because parents are outside of a court context, come up with arrangements for children all the time. And certainly, I don't think that's allowable. That's not illegal, right? So the true issue here is whether you can call on a court to enforce those types of agreements.
Correct, Your Honor. And for example, if we had a child who is 10 years old, for example, or 12 years old, the court may allow parents to enter into agreements privately as long as it's in the best interest of the child. But here, as the trial court argued and correctly argued, that because the child has not even been born yet, how can a contract be entered into by two private parties regarding the best interest of an unborn child? So that was the entire contention.
So that there is a distinction, though. You're saying that if the child was older, let's say 10, 12, et cetera, as you mentioned, then they could enter into a contract like that and the courts would be forced to enforce it?
Your Honor, only if it's in the best interest of the child. That is according to
one. Back to a court would have to go through that analysis in your first point, right?
If an issue is, if an issue was raised regarding that contract, Your Honor, yes.
But then what is the distinction between a 10-year-old and an unborn child? Is the consideration not still what is in the best interest of the child?
It would be, Your Honor, but the burden is higher, especially when the child is a minor or a baby or an unborn child.
Did the court here come to the conclusion that this agreement is not in the best interest of the child?
No, Your Honor, it did not. The court merely said allowing parties to enter into private contracts without judicial oversight is not a good public policy because.
Contracts for parentage, not contracts for access.
Correct. Yeah, I stand corrected, Your Honor. Correct. And 153.007 further states that if a court finds the agreed parenting plan is not in the child's best interest, the court may request the parties to submit a revised parenting plan. Additionally, the terms of the agreed parenting plan or a contract have effects of a binding judgment only after a court has ruled on it. Otherwise, it is not enforceable as an independent contract. Here, honorable justices, the parental contract at hand did not undergo any judicial oversight. The record is clear that the parenting contract was entered into by and between parties privately, although with their assent. And therefore, under the guidance of 153.007, it should not be allowed to, it should not be enforceable as a valid contract because it did not undergo
Was it
judicial
right
review.
to be going under a judicial review at that point if the child was unborn?
I apologize, Your Honor. Can you please?
Would that contract be ripe for review if the child was unborn?
That is a question which I may not be able to answer right now, Your Honor, because that goes to a different process. But the courts are silent on it. The case law that the respondents have reviewed is completely silent on the ripeness of the matter. But hopefully, in the coming years, the great state of Texas can decide on that issue.
So is it your contention that no parenting plan or parental contract entered into in the same posture would be valid or enforceable?
Would you please rephrase that question, Your Honor?
Is
Chief
there
Justice?
any example? Is there any contract for parental rights that could ever be entered into that would be enforceable under your contention, under your client's position? Or is it just this one in particular?
Any contract that is entered into and a dispute doesn't arise out of that contract, bringing the contract under judicial review should likely be enforceable.
So you're basically talking about ratification after the fact. So if the parents acted as if this contract was enforceable for a couple of years, and then one party, your client, for instance, decided that no, the contract is not being enforced, then she could move to void the contract.
She could move to bring the contract before a court, which then would consider the child's best interest before ruling on the contract as a judgment, which will be enforceable additionally. Secondly, if the honorable court finds that the contract is valid, even then, the petitioner still should not be awarded any relationship to the child or any access to the child because it is not in the best interest of the child. Section 153.02 of the Texas Family Code unequivocally states that the best interest of the child shall always be the primary consideration of any court in determining the issue of conservatorship and possession of the access to the child. Additionally, Section 161.001 of the Family.
Counsel, I'm confused on where this comes into the analysis. Is that issue before us today, whether or not this contract would be in the best interest of the child?
Your Honor, it goes to the very heart. If the honorable court finds that the contract is still valid, it will go into the heart of the question that even if the contract is valid, it is not in the best interest of the child.
Is that not an issue for the lower court, specifically a family court?
Your Honor, it could be, but to save the time and the cost of litigation, it would be best if the issue is.
Can a court of appeals make that ruling?
The court should be based upon law, Your Honor.
Are we able to rule on an issue that has not been before us in the briefing?
This issue was implied in the briefing, Your Honor, because this is a subpart of the issue of the contract's validity. Because it goes to the heart, and under 153.07, it is specifically mentioned that a court cannot decide on a parenting plan until it finds it's in the best interest of the child. So
Is the best interest of the child a factual or a legal decision?
Your Honor, it could be a legal decision given our facts, but given the facts of some other distinctive cases, it could be a factual decision.
But your position is that it is a legal.
Yes, Your Honor, because Section 16101 of the Texas Family Code allows the court to terminate a parent-child relationship if it finds by clear and convincing evidence that the parent has engaged in a conduct or knowingly placed the child.
That's an entirely different, right? That process is very complicated and very complex, and that's not the posture that this case is in right now. This case is in a posture of determining whether or not the parenting contract is valid under public policy. Am I correct?
That would be correct, Chief Justice.
So the question about whether or not the 161 that you just mentioned, that assumes that there is a parenting or a parent-child relationship to begin with. And your argument and your co-counsel's argument is, as I have understood, that there was never a parent-child relationship to begin with.
That is correct, Your Honor. I was giving that argument, or the respondent was giving that argument in hopes that in case court remains unpersuaded by our previous arguments, then this could act as a secondary argument. But I can totally.
Justice mentioned, is that not an issue of fact for the trier of fact to determine? And even if, let's say this is before us, I think the lower court put it nicely that the court should exercise extreme caution in meddling in areas in which neither it nor the parties involved possess the expertise to determine when and how a person can become a parent. And as your co-counsel had mentioned extensively throughout, you're trying to restrict access from one parent to another, which is a confusing area that I'm still not clear on whether or not y'all think he's a parent or not. But these are all based on fact questions, right? You presented 3 distinct areas of fact for us to make a determination on whether or not he should be allowed to have access in the best interest of the child, which, again, I guess I'm confused now even saying it out loud on what is the, if you can point us to the direct argument here on why it is before us and why we should rule that way.
Your Honor, going back to, and I see I'm about to run out of time, so is it fine if I conclude my thought?
Just wrap
Thank you.
it up for us.
Thank you, Your Honor. So Section 153.007, which is at the core of contract's validity, in itself says a court shall only find a contract entered into by and between private parties to be enforceable as a court judgment if it is in the best interest of a child. Therefore, the best interest of the child analysis is paramount to the issue at hand. And because the lower court did not address that issue, the respondents felt the need to bring it up here in the chambers here, so Your Honors and this court could hear it instead of remanding it back to the lower court in essence of litigation costs and time. That said, Your Honor, the respondents pray the court to affirm the lower court's judgment on the issue of contract formation.
Thank you.
Chief Justice, Your Honors, may it please the court. I want to address a few things that respondent has claimed here. I'm going to address first the contract issue, and then I want to talk about some of the allegations they've had about petitioner. For the contract issue, respondent repeatedly brought up the importance of judicial oversight, judicial review. However, my co-counsel mentioned one possibility, one outcome of this case today could be remanding it to the lower court to see if it is in the best interest of the child.
So what is your determination?
So when we were talking about the contract, and this goes to your point, shouldn't we assume that the court did in fact do a best interest analysis and that it was implied by their decision? Like that's what we would do, is assume that the court had done the best interest analysis and came to the decision that it came to, not because the contract itself was void as a public policy or because of public policy, but because it had done the best interest of analysis and the public policy analysis.
Your Honor, I believe the lower court was more focused on the implications for public policy. They did no best interest of the child analysis that I could see. Additionally, speaking on the best interest of the child, something that the respondent brought up was a case in which a father's parental rights were terminated, but as one of your honors pointed out, that case involved a father that hadn't seen his child in years. However, the case at hand, petitioner was never even given the chance to see his child. He was never given the opportunity to develop that relationship. He was cut off before he could even prove himself to be a good father to his child. Additionally, something respondent brought up is how respondent doesn't deserve to have her parental rights stripped away. Nothing that we have talked about here today would imply that we want to strip respondents' rights away. In fact, we believe that having two parents, the reason why it is so important to have two parents is because in the case where one has trouble with their business, such as what happened with petitioner here, or loses their job, the other one can come step in, pick up the slack. That is why it is so important to have two parents. Their very argument that petitioner is not suited to be a father because of his business failing and he wasn't able to make payments, them pointing that out actually supports my argument that it's better to have two parents, because what if in the future respondent loses her job? What if she can't pay for childcare or she can't pay for food for her child?
What you're making is a best interest argument, though, and that is more appropriately directed toward the trial court.
Yes, Your Honor. I was just trying to establish that in the equal protection context, because the compelling interest is the best interest of the child, making such a harsh distinction between married and unmarried donors does not serve that compelling interest. I see I'm almost out of time, so I'm going to go ahead and wrap this up. At the end of the day, if petitioner had been married to respondent, he would have had parental rights. This cannot be how we decide parental rights. Parental rights should be about close familial relationships and the best interest of the child. It should not be such a harsh distinction between whether you're an unmarried donor or married donor. Thank you.
Thank you.
Respondents and petitioners will wait outside while the judges do your scoring.
Good one. Good. I can finish my chips.